Good morning, all of you. It's good to be back at the VCC for ICAI. It's been a long after which I've come back. So this year has been such that somehow one or the other person has been fallen sick. So same has been with me. I could not complete my classes with inter students, and now I'm back in shape, back in health, and ready to take your classes. So today we are going to start with one of the provisions, one of the legislations that has been provided for in your syllabus, which is Arbitration and Conciliation Act 1996. Now, this is a part of your paper 4, which is corporate and economic laws, right? Now, when you talk about this, the first question that comes to the mind of the students that, ma'am, we are going to be chartered accountants. Why do we need to read about arbitration? Or what is the importance of this legislation, considering it's a whole legislation that we are talking about from the exam point of view? So let me answer the second question first, that it is important from exam point of view. Get to see questions from 3 to 4 marks from this topic. Now, other than that, why is it relevant for students who are going to be chartered accountants in the future? Now, you need to understand, with the change in scenario and with the alternate dispute resolution mechanisms picking up, there is a need for knowledgeable specialized professional, like the professionals who are skilled in a particular field, to become arbitrators in order to resolve disputes, company disputes, or the disputes that occur between the parties. So, because chartered accountants are skilled with all kinds of financial transactions of the company, they are very well placed to become arbitrators and to be able to resolve the disputes and not go to the standard litigation mechanism. This is why this is very, very, very relevant topic for the students. If you would have ever seen the ICI page, you would have noticed that they offer even courses for qualified chartered accountants who have completed, I think, 5 years of practice to become arbitrators, right? So it is a relevant area. It is a very, very interesting area, very simple topic, totally theoretical in nature. Basics are there, but it is a fun topic. So if you try and focus, you will get to know it's a very simple topic. There's nothing clumsy about it. It's straightforward, clear-cut legislations where things have been clearly defined. All you need to understand that in India, with the developing economy, with the developing society, human needs, there was a increase in the conflict of interest among the parties. People also became more conscious about their individual rights, and therefore litigation became an inevitable part of their life, because of which there was a rising incidence in the disputes. Now, there were certain problems associated with the standard litigation process. Firstly, they were very, very time consuming. They're very technical and complicated in nature. There are a lot of hidden cost associated. So not just you have to pay to your lawyers, or let's say if you are even opting for free legal aid, still there are so many hidden costs associated, like the cost of getting papers out, the cost of getting certified copies, procedural fees, court fees. So there are a lot of hidden cost, plus high amount of pendency in our courts. So even though there has been a lot of technological advancements with our judiciary, with the COVID, you got to see that a lot of hearings were done virtually on digital platforms, and we ourselves have done that. But not every state is still ready or good to go with the virtual mechanism. Yes, Delhi has been very good, Mumbai has been good, but smaller states like Haryana or UP, still they are not very, very up to the mark with the digital program. So in order to meet the needs of the people, to reduce the burden of the courts, there was a need for a dispute resolution mechanism other than the court procedures, right? Now, the question arises, is it something really new that we have brought to our society, or it has always been existing? So if you try and understand the way India was formed, there was always a system of alternate dispute resolution. There was panchayats, okay, there were lok adalats. There were also a system of where the elders in the family used to sit together and try to resolve the disputes. So what are all these? These are alternate methods of resolution of disputes. So you will see the presence of alternate dispute resolution, and as old as if you look at our Vedas, there also you find the mention of alternate dispute resolution. Now, this term that we talk about, which is alternate dispute resolution, what does this mean? It just means another methods of resolving disputes in between the parties, the methods which does not involve directly going to the court of law, or it does not involve directly going to the judiciary, right? So yes, there is resolution of disputes. The party to whom we are reaching out, they have the authority to resolve the disputes, but we are not going with a regular litigation mechanism. We are looking for alternate methods, right? What are these alternate methods? Like mediation, conciliation, negotiation, lok adalats, all these are alternate methods of dispute resolution, right? So this is a brief basics on the alternate methods of dispute resolutions and the procedures that are followed. Are we good till here for everybody? Are we good? Are we good to proceed? I want students to be a little interactive with me on this class, because if all of you are not interactive, there will not be any fun in taking the class. So try and respond, because that way you will also not get bored of just listening to what I'm saying. So for questions also, once we will finish one topic, I'll give you a few minutes to discuss any queries that you have and then proceed further. So are we good till here, students? Okay. Now coming on to the basics of Arbitration and Conciliation Act 1996. So the question arises, was it the first time did we have the Arbitration and Conciliation Act, or in the past also there were some sort of arbitration procedures that were existing? Do you get this question in mind? So there were legislations in the past, but the Arbitration and Conciliation Act 1996 was based on the UNITROL model. So this United Nations Commission on International Trade Law, this is the agency who monitors the international trade, and they develop the framework for the functioning of the trade internationally. So they had developed a model law for resolution of disputes when they happen in case of international trades. So this Arbitration and Conciliation Act was built on the lines of the model law that had been provided under the UNITROL, right? So this act, which is the Arbitration and Conciliation Act 1996, it is an act to consolidate and amend the law relating to domestic arbitration, international commercial arbitration, and enforcement of foreign arbitral awards. So if you try and figure out from this law basically takes care of three areas. One is the domestic arbitration, that is the arbitration take place in India regarding disputes between the parties who are Indians. Second is international commercial arbitration. So arbitration in which the seat of arbitration is India, but maybe the parties are international or non-Indians. Third is the enforcement of a foreign arbitral award. So let's say an arbitral award has been granted or awarded by a foreign institution of arbitration. In that case, how those foreign arbitral awards would be enforced? How will they be executed? So these are the basic three key areas which have been entertained or taken care of in the Arbitration and Conciliation Act 1996. It also contains provisions relating to the conciliation. So arbitration and conciliation both are taken care of in the Arbitration and Conciliation Act 1996. Now the question arises, do we have a comprehensive legislation for mediation as well? Because when we talk about ADRs or the alternate dispute resolution mechanisms, arbitration, conciliation, mediation are the three words that we see or hear most often, right? But till date, we do not have a comprehensive specific legislation for mediation. Yes, mediation finds its place in civil procedure codes, we have mediation centers in our country, but do we have special centers that have been made for resolution of disputes through mediations? There are courses for mediators, but do we have a comprehensive legislation as of now? We do not. But yes, a bill has very much, a draft bill has been proposed for consultation of the public on mediation, right? There are a lot of things that I will be telling you here, which is not really a part of your case material or syllabus, but they help you to understand the topic as a whole. So yes, it is very much possible for me to restrict myself only to the study material, but that will not give you a holistic understanding on the functionalities of this legislation. So yes, your syllabus is limited to what has been provided in your study material for your exam point of view, and you will get to see the questions along those lines. But there will be a few things that I'll be talking about in order to help you connect with the provisions or things that I am saying. Okay. So the applicability of this law. So this act extends to the whole of India. So earlier there were some restrictions for Jammu and Kashmir. Now with the abrogation of 377, even that has been done away with. So this act extends to the whole of India, and it came into force on 22nd August 1996, wide notification number GSR 375E. Now, this act aims at streamlining the process of arbitration and facilitating conciliation in business matters, so which we already know. There are few important features which are the beauty of this act. This act provides a lot of autonomy to parties. Autonomy in terms of deciding on the procedure for resolution of disputes. Autonomy in terms of choosing the law to which they want to be subjected to. Autonomy in terms of choosing the place or the seat of arbitration. In terms of choosing who would be the person who will take the role of a judge or who would be the arbitrator and help in the resolution of disputes. So the autonomy of parties that we talk about is one of the key and most important and significant feature of arbitration, which makes it extremely lucrative for resolution of disputes, right? Now let's talk about the structure of this act, which is Arbitration and Conciliation Act 1996, how it has been structured. So basically it consists of 4 parts, 88 sections and 7 schedules. So part 1 consists of 10 chapters that deal with arbitration. Part 2 deals with enforcement of foreign award. Part 3 deals with conciliation. And part 4 deals with certain supplementary provisions. So it's a bit huge legislation, not really huge, but it is a decent set of sections, 88 sections it has with 7 schedules. But all of these sections are not a part of your syllabus. So for your syllabus point of view, you only have to restrict to what has been the sections or the content that has been provided in your study material. That is more than enough, right? Now, coming to the basics of alternative dispute resolution. So this alternative dispute resolution is very much enshrined in our constitution as well. So when we talk about equality, right to justice, all of it is enshrined in our constitution, including what has been mentioned in the directive principles of state policy. So the Supreme Court of India, they also recognize the right to speedy trial as being implicit in the Article 21 of the Constitution of India. And they said that it was important that the justice should be delivered in shorter amount of time. The trial should be speedy. So if you're aware, all of you know that litigation takes a lot of time. There are cases which have been pending in court for 5 years, 10 years, 15 years. There have been news or there have been cases where a judgment was delivered after the original petitioner and the respondent had died, and after then the judgment came. So we always say this, that justice delayed is justice denied. So right to speedy trial is very much a part of our constitution as well. So in order to give effect to this mandate, the Parliament of India has recognized several ADR mechanisms, or the alternative dispute resolution mechanisms, and these includes like arbitration, conciliation, mediation, negotiation, lok adalats, and they further support the judicial system. So if you would have noticed, over a period of time, there have been new wings coming up. There are new tribunals, that like there is a company law tribunal, we have a separate company law tribunal, we have a separate tribunal for NGT, which is National Green Tribunal, we have a separate tribunal or fast track courts for POXO legislations or Terrorist Act, STADA, right? So these mechanisms are being developed in order to reduce the burdens on our judiciary, and also have mechanism that can lead to speedy disposal of suits or complaints or disputes, right? Now, talking about what is meant by ADR, what do you understand by the term alternative dispute resolution? So it refers to a means of settling dispute outside the courtroom, right? So procedure which is outside the courtroom. So do we necessarily understand that there is no technicality in these procedures? There are no guidelines, no specific SOPs for this? No, that's not the case. So even when you go for arbitration, yes, it is expensive. Arbitration in India is not cheap. It is expensive. Hefty fees are paid to the arbitrators. Whether you go for an institutional arbitration or you go for an ad hoc arbitration, there are fees, there are procedures. So here, not only Arbitration Act is important, even the Civil Procedure Code becomes relevant, because the procedure for resolution of dispute, the civil disputes, has been provided in the Civil Procedure Code. However, you don't have to get into so much of detail, because that's not going to help you. As chartered accountants, you don't need to know so much of details of procedure. But yes, you should very much understand the basics. Now, talking about the advantages of ADR. So first is that the cost is lower. There is a greater flexibility of the process, higher confidentiality, greater likelihood of settlement, the choice of forum, and the choice of solution. So this is a bit of informal method where there has been a lot of autonomy given to the parties, and because there is a high amount of confidentiality, any discussion that happens during arbitration proceedings is highly confidential, and any content of it is not to be discussed with any of the third parties. So because of its confidentialities, the parties also have confidence that they can share all the information that can help in resolution of disputes. Another very important part of this ADR is, if you try and understand, the judges who are sitting in the judiciary, they come only from law background, right? They understand the law, they understand the implication of law, they understand the interpretation of law, right? But when you talk about company-related disputes, industry-related disputes, let's say there's a dispute between L&T and Government of India, right? So what is L&T? L&T is a construction company. So if you have ever had a chance, or if you would have seen the contracts, if you read the contracts that are entered into with the government to build bridges or to build a metro railway system, they're highly technical. There are words, there are timelines, there are procedures, there are words that are used in civil engineering field. So a lot of time, understanding those technical terms can be difficult for judges. But when you choose an arbitrator, you choose a person who has an expertise in that field, who understands the functionality of those fields, who understands the nitty-gritties of operation of those contracts, or how does that particular industry function. Because that particular person has a key understanding of that area, he is able to come to a better conclusion or to provide a better solution to the problems or to resolve the disputes. This is also one of the very, very important advantages or feature of the arbitration as such, right? Next, we talk about of the disadvantages of ADR. So it requires cooperative behavior of both parties. There is power imbalance between the parties. There is the lack of the possibility of interim measures, and there is a difficulty in enforcement of final outcome. So these are certain disadvantages of ADR. So as of now, we are generally speaking of the alternate dispute resolutions, right? Now let's talk about the legislations that deal with ADR. So if you talk about Lok Adalats, they find a mention in the Legal Services Authority Act. Arbitration and conciliation is governed by Arbitration and Conciliation Act 1996. Civil Procedure Code is also important, section with the introduction of Section 89 in the CPC, which was amended in 2002. Conciliation, mediation, and pre-trial settlement methodologies have been introduced and accepted for the resolution of disputes. As of now, as I told you, we do not have a comprehensive legislation for mediation, but a bill has been proposed for public consultation in 2021, right? So are we good till here? Everybody is through with the basics and the concepts of alternative dispute resolution? Any questions till here? Any queries? Or should we proceed further, students? Okay, so I'm proceeding further. So the next topic that we are going to talk about is arbitration. So as of now, we were discussing the basics of alternative dispute resolution. Now we are going to discuss arbitration at length and the provisions. So arbitration is an adjudicatory process in which a dispute is submitted to an impartial outsider who makes a decision which is binding on both the parties. So there are certain keywords that you get to see. The first keyword is that it is an adjudicatory process. So it's a process for adjudication of disputes. Who resolves the disputes? It is an impartial outsider. So impartiality, lack of biasness becomes an important feature, that the person to whom the dispute has been submitted, he should adjudicate upon the matter impartially. He should not be biased. Then this impartial outsider, he makes a decision, and this decision is binding on both the parties. So if you see here, the involvement of the Indian court system is very, very minimal. The parties themselves decide that in case of dispute between them, who will be that person, who will be the arbitrator, or who will help in the resolution of dispute, right? And then this person has to impartially, without any bias, adjudicate upon the matter and then make a decision, and this decision is binding on the parties. Then does this mean that there is no remedy against unfair treatment by an arbitrator or incorrect order passed, or there is no provision that we can challenge the arbitral award? That's not the case. We have limited areas available where court intervention can be taken help of, or court can intervene, but there are limited grounds in which the courts can intervene. Because if for everything we reach out to the court, the entire purpose of having alternative dispute resolution gets nullified. So there is no point having an alternative dispute resolution mechanism when we have to run to the courts for everything, right? So this arbitration is one of the oldest systems of ADR and has been administered by the traditional state. So for a valid arbitration, there is a prerequisite, that is a arbitration agreement. There has to be an agreement between the parties that whenever there is a dispute between them, they agree to resolve their disputes by arbitration. Now, because this is an agreement between the parties, it should fulfill all the requirements that had been provided for in the Indian Contract Act. That is, the parties should be of sound mind, should have attained the age of majority, should not be a minor. The consent should be free and not obtained through misrepresentation, force, or undue influences. The objective should be legal in nature. So the basic requirements of a valid contract have to be fulfilled, right? So now the question arises, can a person be forced to get into an arbitration? No. It is the free will of the parties. If they consent to it, they both agree to it, the disputes can be resolved through arbitration. Now, this is a decision the parties make at the time of entering into a contract, and they very much include the provision for the dispute resolution. So when I say arbitration agreement as such, we don't necessarily all the time see a separate agreement for resolution of disputes, but the agreements or the contracts that are signed between the parties, let's say a general contract for construction of bridge. So the terms and conditions of the contract would include a provision or clause for resolution of dispute, which always talks about the ADR method. So these days, whenever you look into a contract, if you go to the clause which talks about resolution of disputes, 90 to 95% situations, you will get to see that the first clause always talks about a ADR. And after ADR, then there is court mechanism, right? So now let's start discussing key important words or terms that will be used in this legislation and that have been defined under the Act. So before we proceed on the relevant terms, are we good till here, or do we have any queries from students? Students, feel free to share any questions that you have, because that way the class becomes communicative, and it is always better to have students interacting with the faculty. So no questions till here. We are good to proceed. Okay. Perfect. Now talking about the relevant terms that have been provided under the Arbitration and Conciliation Act. So we know, all of you are students of final, and you already know that the definition is generally provided in section 2 of the Act. So here the word arbitration has been defined in section 2, and it means any arbitration, whether or not administered by permanent arbitral institution. What do you mean by that? What is this definition trying to say? So generally what you get to see, there are two kinds of arbitration. One is an ad hoc arbitration and one is an institutional arbitration. So what is an ad hoc arbitration? Ad hoc arbitration is when you basically choose an arbitrator who is an independent person to arbitrate the dispute between the parties, right? And institutional arbitration is an arbitration where there is a body, there is an institution that has been created to resolve the disputes between the parties. So institutional arbitration have their own laws, they have their own rules, they have their guidelines, they have a list of arbitrators that have their available on the boards, they have efficient administration, they follow strict timelines, the quality of arbitral tribunal is under control. So that is an arbitral institution. So we have ICA in India, we have a Singapore Institute of Commercial Arbitration, we have ICC. So there are a lot of institutions that are arbitration institutes in India. So either the provisions or the guidelines of arbitration agreement can say that the parties will choose an arbitrator who will arbitrate the dispute or resolve the dispute, or they can say that any disputes occurring between the parties will resolve by the rules and regulations that have been provided for in the ICC. So that becomes a institutional arbitration, right? Now, the next term is the word arbitral tribunal. So for arbitration, when we talk about the body who is arbitrating the matter, you always see the word AT, which is arbitral tribunal. Now, tribunal does not necessarily mean that it's going to be a panel of arbitrator. If he is a one single arbitrator, then also it is called an arbitral tribunal. If it is a panel of arbitrators, then also it is called an arbitral tribunal. So the number of arbitrator has no role on the definition of the word arbitral tribunal. So it means a sole arbitrator or a panel of arbitrator. The third term word is the word arbitral award, and it includes an interim award. So an award that has been awarded in between the proceedings of arbitration, that is called an interim award. So it is not yet final. It does not resolve all the dispute or does not address all the concern, but still it is an interim award that has been granted. Next is the word international commercial arbitration. So section says it means an arbitration relating to disputes arising out of legal relationships. So the word legal relationships is important. So this word was picked from the Unictrol model law. So there has to be legal relationships. So the question arises, can any dispute concerning illegal activities be resolved through arbitration? No, it cannot, because it involves arbitration relating to disputes arising out of legal relationship, whether contractual or not, considered as commercial under the law in force in India, and where at least one of the parties is an individual who is a national of or habitually resident in any country other than India. So for international commercial arbitration, at least one of the parties should be an individual who is a resident of another country, or is a national of another country, or he resides in any country other than in India. Or it could be a body corporate which is incorporated in any country other than India. So let's say Apple Inc. So it's a body corporate which is incorporated in US. So let's say there is a dispute between Xiaomi and this Apple Inc. It will become an international commercial arbitration. So recently, if you see, there has been dispute between Future Group and Amazon. Future Group and Amazon were having a dispute resolution at the Singapore Center, Singapore International Arbitration Center, right? An association or a body of individual whose central management and control is exercised in any country other than India, or the government of a foreign country. So where there is a dispute with the government of the foreign country, then also it becomes an international commercial arbitration. The term party means the party to an arbitration agreement. The people who have signed the arbitration agreement, they are called party, right? The next is the word arbitrator, which is most widely used, but they have not been defined in the Arbitration and Conciliation Act. But if you generally understand it, he's a person who is appointed to determine differences and disputes between two or more parties by their mutual consent. It is not enough that the parties appoint an arbitrator. The procedures and the guidelines have to be followed. So are we good till here? Any confusion in the definitions part? Shall I proceed further? No confusions on the definitions? Okay. Now talking about the process of arbitration or how the arbitration takes place. So generally what happens, you largely get to see, let's say there are two companies, okay? One is Milton India, and one there is a large scale manufacturer. So let's say Milton is entering into a contract with ABC to be his vendor to manufacture a specific kind of vacuum flask bottles, right? So obviously when there is a commercial relationship between the parties, there are high chances there can be some sort of disputes. The disputes can be related to the timelines of the delivery of goods, disputes related to the payment, disputes related to the quality of goods, disputes related to breaking the exclusivity. So let's say a particular design was to be manufactured for Milton only, and that vendor manufactures the same design for Cello as well, right? So such kind of disputes often arise between the parties. So when there is a dispute between the parties, how it will be resolved? So generally what you get to see, that the parties appoint an arbitrator. So either one single arbitrator can be mutually appointed by the parties, or both parties appoint one arbitrator each, and these two arbitrators jointly appoint a third arbitrator who is called an umpire. Now this arbitrators, the tribunal, the arbitration tribunal, they are provided the dispute, the entire set of documentation with clear-cut complaint or the petition which mentions the dispute that is there between the parties is presented to them. They adjudicate upon the matter, they take statements, they investigate the evidences, and they come to a conclusion which is called the arbitral award, and which becomes binding upon the parties. There are certain grounds that have been provided for the challenging of the award under Section 34, and those are limited areas under which an arbitral award can be challenged. Else, it remains binding on both the parties, right? So this is how a general basic arbitration proceeds. Now talking about the basic features of arbitration. What are the key features of arbitration? So the first and foremost important feature of arbitration is an arbitration agreement. So this arbitration agreement is a binding contract between the parties that whenever there is a dispute, they would not go to the court and they will proceed to arbitrate their dispute. So the clause that you generally got to see, it will be languaged in a way that in case of any disputes arising between the party pertaining to A, B, C, and D. So it is very much defined that what kind of disputes will be resolved through arbitration. So if it is dispute which is beyond the scope of that arbitration agreement, that will go to the court, right? So arbitration agreement is this binding contract between the parties. So when I say binding contract, I'm repeating again, it does not necessarily always mean that there is a separate contract that is entered. A lot of time there is a provision, there is a clause in the main contract itself, which talks about resolution of dispute, and this clause itself is considered as the arbitration agreement. Is that clear? Please don't be confused here. Even though the word arbitration agreement has been used, if you get to see a particular provision or a particular section in the act, in the agreement, that is also considered as the arbitration agreement, right? Okay, there are a few queries that I've got. First, Pradeep is asking me, ma'am, practically arbitration is solved by lawyers. Yes, we see a lot of lawyers being present in this industry who are arbitrators, but a lot of professionals like chartered accountants, company secretaries, or senior people who resign, let's say, as the director of Indian Oil or a director of DRDO, we see even such people are arbitrators. So a lot of times you see the companies which are involving high stake matters, they have a panel of arbitrators. They don't appoint just one person as an arbitrator. So one of the person may be a person holding an expertise in that particular technical knowledge in that area. There would be another person who would be very good in terms of understanding of the procedure of law. So this is why there is a provision for providing for a panel of arbitrators as well, right? Next question is by Sumit. He's asking me, ma'am, arbitral tribunal is to be set up under this Arbitration Act. No, Sumit, arbitral tribunal is not like a company law appellate tribunal that we get to see, or company law tribunal that has been set up under the Companies Act and there's a separate code for that. Arbitral tribunal is nothing but a person, maybe me or you, if you become a chartered accountant later and qualify as an arbitrator. So it is just a person, he, himself, or 2 or 3 people together become the person who resolve the dispute. So there is no as such setting of a court as such, but they definitely resolve the disputes by sitting. There is a place that is decided. They sit in the meeting room, conference room, and then adjudicate upon the matter. So you don't get to see that really court wala setup that we are talking about. Is that clear, Sumit? Sairam is asking, ma'am, there is any degree to become an arbitrator? Yes, there are qualifications that have been provided for. Expertise in the field is very much one of the key requirements to become an arbitrator. Along with that, you get to see, if you visit the website of ICI, even they have course for becoming an arbitrator. So you can qualify for that and become an arbitrator. Okay. So this confusion with the arbitral tribunal is clear. So okay. Now coming back to the key features of arbitration agreement. Key features of arbitration. I'm so sorry. So arbitration agreement we have discussed. The second point is we need a arbitrator. So whether it is one arbitrator who is chosen or it is a panel of arbitrators like 3 or 5 or 7, they are known as the arbitral tribunal, and they are very much similar to the judge of the court. These are the people who decide the disputes between the parties. Now, because they are adjudicating upon a dispute, they are supposed to be neutral, impartial, and unbiased. If at any point of time any kind of favoritism or biasness is observed, the party who is aggrieved can very much reach out to the court requesting for the change in arbitrator. Also, you have to understand this arbitrator that we are talking about, it is generally chosen by the parties themselves. So there is a timeline that is provided that when there is a dispute, within 30 days from the date of written complaint or the date of informing the dispute to the party, they will mutually appoint an arbitrator. Only when they are not able to do that, they reach out to the court for their intervention and help. So the aggrieved party, where he notices that there is a delay in appointment of arbitrator and the guidelines that have been provided in the arbitration agreement is not being fulfilled, they can very much request or seek the intervention of the court, right? Now, one of the important things that you need to see here, because these arbitrators are the people who are chosen by the parties in dispute themselves, they have a lot of confidence in them, right? And plus, these people, because they come with some sort of technical expertise, the parties are more comfortable in sharing all kind of technical information. Is that clear? Next is the seat of arbitration. So when I say seat of arbitration, it does not necessarily only mean the place or the venue of arbitration. It also means the country to whose laws you would be subjected to. So let's say there was a dispute between Future Group and Amazon. Their seat of arbitration is Singapore. So by the way, let me tell you, Singapore and London has actually emerged as a hub for international commercial arbitration. Singapore definitely has. So even though Amazon is a US company, Future Group is an Indian company, their seat of arbitration is Singapore. They have chosen themselves to be to resolve their dispute through a institutional arbitration, right? So the arbitration is done by the Singapore Institute of Commercial Arbitration, if I'm not wrong, right? So see, when you choose the seat of arbitration, you are basically subjecting yourself to the laws of that particular country. So when you say that the seat of arbitration would be Singapore, and you agree to be subjected to the laws of Singapore. So when there is a dispute or there is a court intervention needed, the courts of Singapore will intervene in the matter, right? Similarly, if India is the seat of arbitration, then Indian laws would be applicable and Indian courts will have the authority to provide supportive assistance whenever there is requirement for a intervention, right? And the court who would hear challenges would also be subjective to the seat of arbitration. Is that clear? Okay. Is asking me what is the difference between arbitration and liquidation. Arbitration, Geeta, is a method of resolution of dispute. Liquidation of a company happens when company's debts are way higher than their earnings. Then the assets of the company are liquidated, are dissolved in order to pay off the debts. How come they are similar? In arbitration, one of the decision that would have been taken by the arbitral tribunal could be that the assets of the particular company would be liquidated and a company would be paid. So let's say there's a dispute between company A and company B regarding payments, right? So let's say payment of 100 CR or something is due. So arbitral tribunal can very well pass an award that some of the asset of the company would be liquidated in order to pay off this debtor. But arbitration and liquidation are nowhere linked. I don't know how come you ended up linking arbitration and liquidation. Arbitration is a method of resolution of disputes between parties, and it is a type of alternative dispute resolution. Sumit is asking me, ma'am, can arbitration be filed in foreign countries only when there is one foreign party, like in case of Amazon? Not necessarily. So if you see, autonomy is one of the key features of arbitration. So if the parties want, both the parties are Indian, if they want, they can choose to resolve their disputes through institutional organization and have their seat of arbitration in a country other than India. There's nothing wrong in that. There's no restriction on choosing on the seat of arbitrations. Companies are free, or the parties are free on to decide on their place of arbitration. Is that clear, Sumit? But you always have to remember that there are associated costs. So when you choose Singapore as your seat of arbitration, every time there's an arbitration hearing, you have to fly down to Singapore. Your arbitrator would be from Singapore, maybe. So he would be paid according to the Singaporean currency, Singaporean dollars. So there are associated costs that are taken into consideration when the seat of arbitration is determined. So it all depends on the scale of business, the matter that we are talking about, the kind of disputes that we are expecting, what is the stake that the parties have in the agreement that or the project that they have entered into, right? Yes, arbitration is an acceptable method of alternative dispute resolution across the world. Even the United Nations proposes for arbitration as a method of dispute resolution. So yes, separate countries have their separate laws, just the way India has Arbitration and Conciliation Act 1996, but it is a universally accepted procedure for dispute resolution. The next key feature of arbitration is party autonomy and procedure. So when we say party autonomy and procedure, we are trying to say the choices that the party has. The party has a choice to decide on the applicable law, to decide on the seat of arbitration, to decide on who the arbitrator be, to decide on the procedure, the timelines, like whether it will be one arbitrator or it will be 3 arbitrators or 5 arbitrators, who would be those arbitrators, what would be their qualification, what kind of disputes we want to be resolved through arbitration. So it is very much possible that the parties specifically define that only A, B, and C disputes arising from this contract will be resolved through arbitration. So let's say if there is a dispute other than that has been defined for, then it will be resolved through normal litigation process. So there is a lot of autonomy provided for space that is available to the parties to decide on the procedures for the resolution of dispute. The next is the arbitral award. So this award that is passed by the arbitrator, the decision that is given by the arbitrator, it is the binding on the parties, and there are very, very limited grounds available under which they can be challenged. Next is finality of outcome. So generally there is no appeal against an arbitral award, but there are few grounds under which they can be challenged, like an invalid arbitration agreement, the party's incapacity to enter into contract, the independence of the arbitral tribunal, or the biasness of the arbitrator, or unfair procedure. So these are some of the grounds that have been provided for in section 34 of the Act. Another important feature is confidentiality. So whatever happens in arbitration, it remains private. It is only known to the parties and the arbitrators. And all of these people are prohibited from sharing the information to any person who is not involved in arbitration. Any document, any information that is received during the course of arbitration, it remains confidential. So basically this is done so that the parties feel confident enough to be able to share all kinds of information that can be used to come down to a proper solution that can help to resolve the disputes between the parties. Next is the enforcement of arbitral award. So we have procedures for enforcement of domestic arbitral award also, and international arbitral awards as well. Okay, so are we clear with the features? Sumit, you are right. This act applies to whole of India, including Jammu and Kashmir. But I'm not saying this act applies to a foreign jurisdiction. A party of a foreign jurisdiction might want to choose to be subjected to this act. So let's say, if you look at this dispute between Future Group and Amazon Group, Future is an Indian company, Amazon is a US company. What did they do? They chose a neutral jurisdiction. So Singapore is a neutral jurisdiction for both India, for both Future and Amazon, right? This is why they chose Singapore and decided to be subjected to the Singaporean laws. So I'm not saying that it applies to a foreign jurisdiction. I'm saying that a foreign award, let's say an award has been granted by arbitral award has been granted in Singapore, but it needs to be executed in India. So if it needs to be executed, we have provisions and guidelines for execution of those foreign award. Is that clear, Sumit? Please answer me, Sumit, if it's clear. Yes, Sairam, you're right. Arbitral award is the decision that is passed by the arbitrator to the parties. Now let's talk about differences between litigation and arbitration, or key distinctions between arbitration and litigation. So litigation takes place in court. But in case of arbitration, the place of arbitration is chosen by the party. It could even be the conference room of a hotel. It could be the conference room of the company. It could be anywhere. A judge is assigned by the court and the litigant has no say on who will judge their dispute. But in case of arbitration, the arbitrator is selected by the parties. It is only when the parties are unable to select the arbitrators, one of the parties can reach out to the court and request for appointment of the arbitrator. So because there is a party autonomy in the choice of arbitrator, they can choose people with appropriate expertise, educational qualification, trade experiences, etc. as arbitrator. So the procedure followed by the court is fixed and determined by the rules of the court. In India, it would be governed by the Civil Procedure Code and the rules that are applicable to the particular code. Here, the parties have adequate flexibility to choose the procedure that would apply to their arbitration. They could either construct such procedures or adopt procedures of an arbitral institution. So either they can have their own guidelines and procedures in place, or the procedures that has been prescribed by arbitral institutions can be taken into consideration. So usually a lot of times bigger companies go for institutional arbitration because they are more structured, better managed, they better follow timelines, they have already a panel of arbitrators from whom an arbitrator can be chosen from. So it becomes easier to operate. So yes, a lot of companies these days are preferring for institutional arbitration. The proceedings are generally open to public. In other words, there is little privacy and confidentiality. But here, in case of arbitration, confidentiality is one of the key characteristics. So apart from the parties and their lawyers, there is no other person who is permitted to participate in the arbitral proceedings. Court decisions are subject to numerous appeals. So let's say if your matter is in trial court, you go for an appeal to the High Court, from High Court to the Supreme Court. So there is no finality of decisions. It takes a lot of time by the time the final award comes from the Supreme Court. But arbitral awards are final in nature. They can be challenged on very, very limited grounds that have been specifically prescribed under Section 34 of the Arbitration and Conciliation Act. It is often difficult to enforce judgments of court of one country in foreign country, but when it is about arbitral award, enforcing an arbitral award is easier because it is governed by international treaties such as the Recognition and Enforcement of Foreign Arbitral Awards 1958. So there are treaties between countries through which the foreign arbitral awards could be enforced. So are we good till here? Say yes or no, please. Any confusion on this? I'm waiting for your replies, students. Please let me know, are we through with this and we can proceed further? Okay. Now, talking about the authorities under the Act, who are the people who will have authority whenever there is some sort of intervention needed? So, Arbitration and Conciliation Act provides for three different authorities: the judicial authority, the court, the Supreme Court, High Court, or a designated person institution. So judicial authority as such, if you look at the word, it has not been defined in the Act, but it includes court and other wider tribunals like a consumer forum, company law tribunal. So it is a wider concept. So there was a case, this is one of the landmark cases, SBP versus Patel Engineering. It is one of the landmark cases of arbitration. Along with there's a case of AFCON's and infrastructure. So these are some of the landmark cases of arbitration. So in this case, which is SBP versus Patel Engineering, the court observed that a judicial authority as such is not defined in the Act. It would certainly include the court as defined in Section 21E of the Act, and would also include other courts and may even include a special tribunal like the consumer forum. So this concept of judicial authority is wider than the concept of courts that is ordinarily understood, and would include special tribunals and the quasi-judicial authorities as well. So basically every court is a judicial authority, but every judicial authority is not a court. Next is the court. So the word court has already been defined, and after the amendment that came into picture in 2015, when we talk about the international commercial arbitration, the court would be the High Court. So for original jurisdiction, you will reach out to the High Court directly if it is a international commercial arbitration. For other arbitration, it would be the District Court and High Court exercising original jurisdiction. So when I say District Court and High Court exercising original jurisdiction, means the jurisdictions of the courts are segregated based on their on the money. So basically, if you look at as of now, Delhi High Court can take up, Delhi lower courts can take up matters up to 2 crores, right? So if the matter is above 2 crores, the dispute would be referred to the High Court. But for matters involving up to rupees 2 crores, it will be referred to the district court. So this is called the original jurisdiction. So when we talk about courts, and there is an intervention of the court that is needed for the international commercial arbitration, the court would be the High Court, but for domestic arbitration, it would be the district court and the High Court exercising original jurisdiction. Is that clear? Yes, Sumit, the arbitration order can be appealed in the court depending on the jurisdiction. If it is domestic arbitration, it will be district court and the High Court. And if it is international commercial arbitration, it is directly the High Court. But yes, the appeal lies, but there are limited grounds for appeal. Is that clear? What is your concern, Sairam? You just mentioned no, ma'am. What is not clear to you? Please let So basically, whenever we talk about original jurisdiction, we mean that the authority of the court to take cognizance of the cases which can be adjudicated by that court at the first instance. So let's say if there is a theft that has happened in the house, you will first go to the district level courts. You directly do not go to the High Court. And the appellate jurisdiction of the court is to hear the appeal from the lower court. So there are certain matters in which the High Courts are reached out directly. So if you talk about Delhi as such, if the matter exceeds 2 crore rupees, then the original jurisdiction will lie with the Delhi High Court. But if the matter is for less than 2 crore rupees, the original jurisdiction will lie with the district court, that is the lower court. So when we talk about courts, the jurisdiction, the original jurisdiction in case of domestic arbitration, it lies with the district court and High Court. And where it is an international commercial arbitration, it lies with the High Court only. This is what is meant here. Is that clear? That has been provided for authorities for the court, for the word court. So for the court means in the case of an arbitration other than international commercial arbitration. So when we say other than international commercial arbitration, we mean domestic arbitration, right? So in the case of domestic arbitration, the principal civil court of original jurisdiction in a district and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration, if the same had been the subject matter of suit, but does not include civil court of a grade inferior to principal civil court or court of small causes. So let's say you require court's intervention. Court's intervention in terms of challenging the award, right? The parties are unhappy and you want to challenge the award, and it's a domestic arbitration. The award is for less than 2 crore rupees. So if it is for less than 2 crore rupees, you will go to the district court. If it is for more than 2 crore rupees, you will go for the High Court. So basically, when we talk about domestic arbitration, the court means High Court and the district court on the original side. We are not talking about appellate jurisdiction. We are talking about original jurisdiction. The right of the court to first-hand try the matter is called the original jurisdiction. So High Court does not only have an original jurisdiction, it has an appellate jurisdiction also. It hears appeal also. Correct? Now, second subsection says, in the case of international commercial arbitration, High Court in case of its ordinary civil jurisdiction. So wherever the arbitration is an international commercial arbitration, the court will be High Court original site. So in case of domestic arbitration, it can be High Court or the District Court. In case of international commercial arbitration, it is only the High Court original site. Is that clear? This is how you have to remember. Next is, there are certain specific responsibilities that has been entrusted to the Supreme Court and High Court. So where the situation is that the parties fail to appoint an arbitrator, the authority of appointing an arbitrator lies with the Supreme Court and the High Court. So where the arbitration is the international commercial arbitration, appointment of arbitrator can be done by the Supreme Court, and where the arbitration is the domestic arbitration, the appointment of arbitration is done by the High Court. So domestic arbitration, appointment of arbitrator by High Court. International commercial arbitration, appointment of arbitrator by the Supreme Court. So this happens only when the procedure that has been prescribed for appointment of arbitrator or the timelines that has been given in the arbitration agreement is not fulfilled. Let's say there is an arbitration agreement that says that any disputes occurring between the parties in relation to this agreement shall be resolved by arbitration through a sole arbitrator to be mutually appointed by both the parties within 30 days from the date of information of the dispute. So what has happened here? One arbitrator has to be appointed, and that arbitrator has to be mutually appointed by both the parties, and this appointment has to be done within 30 days. So let's say let's say today on, what's the date today? 11th February, Party B is informed of the dispute to Party A. So from 11th February, they have 30 days to appoint arbitrator mutually. So Party B proposed names, A did not agree. A proposed names, B did not agree. Somehow within 30 days, they were not able to mutually appoint an arbitrator. In this case, because this arbitration is a domestic arbitration, either of the party can reach out to the High Court and request for appointment of the arbitrator. Similarly, when the arbitration is an international commercial arbitration, either of the party can reach out to the Supreme Court to appoint an arbitrator. So appointment of arbitrator lies with the High Court in case of domestic arbitration and Supreme Court for international arbitration. When we talk about authorities, the courts who can exercise jurisdiction, when it is domestic arbitration, it will be district and High Court original side. And when it is international arbitration, it is High Court original side. Is that clear? Is that clear, guys? Any confusion on this concept of court and authority? Please let me know. Students often get confused here. Is it clear? Arbitration you get to see largely for commercial transactions, Ira. You don't get to see them for family disputes. They are not resolved through arbitration. It is commercial transactions, civil disputes that are resolved through arbitration. Is this concept of court and authority clear to all of you? The jurisdiction of courts in terms of appointment of arbitrator and jurisdiction on the original side? Please say yes or no. Okay. Proceeding further. Now coming to the term arbitration agreement. So we'll discuss the arbitration agreement in detail. So we know that the heart of arbitration lies in arbitration agreement. If there is no arbitration agreement, there the dispute cannot be resolved through arbitration, they will go to court for litigation. But supposedly, today, two parties have entered into a contract and they did not provide for resolution of dispute through arbitration. Later on, when the dispute occurs, they mutually agree that for this dispute, they want this dispute to be resolved through arbitration. Then is it possible to refer the dispute for and get it resolved through arbitration? Yes, then also it's possible. So all these things we'll be discussing in detail. So we always know that arbitration agreement is the heart of arbitration. If there is no arbitration agreement, there is no consent of parties to resolve their dispute through arbitration. Arbitration will not come into picture. So generally, every party has a right to reach out to the court under Indian Contract Act. And this right cannot be taken away until and unless the parties have mutually agreed and consented to resolve their disputes through arbitration. So there is an exception that has been carved out for arbitration as such. Now, for getting the arbitration agreement into place, consent of the parties is fundamental. So free consent of both the parties should be there, in which they agree to resolve their disputes through argument, and the document which notes this consent is called the arbitration agreement. So the concept of arbitration agreement is spelled out in section 21B of the Arbitration Act and section 7 of the Arbitration and Conciliation Act. So 21B says arbitration agreement means an agreement referred to in, sorry, what did I miss here? Some section has been missed. Let me cross check this. I don't want to quote an incorrect section in front of you so that you later on get confused and ask me. So section referred to in section 7, right? I missed writing section 7 here. So arbitration agreement means an agreement referred to in section 7, and section 7 says arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. So first point is, it is an agreement by the parties. Agreement to submit to arbitration all or certain disputes. So parties can define whether all the disputes pertaining to a contract will be submitted to arbitration, or only disputes pertaining to the payment of money or timelines of delivery of goods will be submitted to the arbitration. So it says arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise. So there can be two situations. Either the dispute has already arisen and the parties agree to resolve it through arbitration, or there can be a situation where the parties already have consented that in future, if there is a dispute pertaining to this, we will resolve them through arbitration. Correct? Is this clear? Is this clear, guys? So I'm repeating again. Arbitration agreement means an agreement by the parties. That means the parties to the contract are agreeing to this, to submit to arbitration all or certain disputes. So either all the disputes will be referred or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. So an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. An arbitration agreement shall be in writing. So an oral agreement is not enough. It is mandatory that the arbitration agreement shall be in writing and be consented to, be given a free consent to by the parties to it. Is that clear? So subclause 4 says An arbitration agreement is in writing if it is contained in a document signed by the parties, an exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means which provide a record of the agreement, or an exchange of statement of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other. So any of it could constitute an arbitration agreement. So wherever through the conversation between the parties, it appears that they wanted to settle their dispute through arbitration, their willingness and the consent was evident. In that case, that communication will also be termed as an arbitration agreement. The reference subclause 5 says, the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the referent is such as to make that arbitration clause a part of the contract. So a lot of times parties may refer to some other contract which contains the arbitration agreement. So that cross-referencing is also permitted and it will be considered as an arbitration agreement. Is that clear? Okay, before I proceed, Pradeep is asking me, ma'am, jurisdiction, how and who will decide? Jurisdiction is already defined in the jurisdiction of the courts. The High Court, the Supreme Court, the lower courts already have their jurisdictions defined. The pecuniary jurisdiction, the territorial jurisdictions, they have already been defined. Based on that, the choice is made whether it will go to the trial court or the High Court. So I told you, let's say the award is for more than 2 crore rupees. Then the appeal will lie to the High Court. But if the matter is for less than 2 crore rupees, it will go to the district court. Now, when we say district court, if we talk about Delhi only, there are a lot of districts. There is a Saket court, there is a Tis Hazari court, there is a Dwarka court, there is a Rohini court. So there are so many courts. Each court has a territorial jurisdiction. So based on the place of the parties, the place of business of the parties, the territorial jurisdiction is determined, and accordingly in that court, the matter will be adjudicated. Is that clear, Pradeep? Pradeep, is this clear? Everybody is clear on basics of arbitration agreement that we discussed? Everyone is clear on that? Please let me know. Then I'll proceed further. Okay. Now talking about types of arbitration agreement. So basically there are 2 types. One is the arbitration clause, which you get to see in the principal contract. And second is the submission agreement. So submission agreement is an agreement to refer disputes that already exist. So if there is an existing dispute, they can be referred to arbitration through a submission agreement, right? So there is an example here. In 2014, Company A, an automobile manufacturer entered into a JV, which is a joint venture agreement, with Company B, the largest manufacturer of tires, for supply of all-terrain tires for its latest car. Both the companies are registered under the Companies Act 2013. Now, there is the first scenario. The JV agreement carries the following clause: all disputes shall be arbitrated in Mumbai. So let's say the clause says all disputes pertaining to this agreement will be arbitrated in Mumbai. That means this is an arbitration clause which talks about the future disputes that may arise. But there is another scenario where the JV agreement does not have a clause relating to arbitration. Then there is a dispute between the parties concerning the quality of tires in 2016. Now, in order to resolve this dispute, parties enter into an agreement that noted that all disputes, including quality of tires supplied by Company B to Company A, shall be submitted to arbitration. So what is this? This is a submission agreement. The parties enter into an agreement to resolve the dispute through arbitration after the dispute has already taken place, right? So two situations can be there. One is the disputes are to be resolved when they arise in future and the parties pre-hand decide to it. Second situation is there is no arbitration clause, but after the disputes arise, parties agree to resolve it through arbitration. So such an agreement becomes the submission agreement, submission arbitration agreement. Is that clear? Is that clear, everybody? Please let me know if this is clear to all of you. Proceeding further, we are going to talk about certain general principles of arbitration. So first principle is that the arbitration agreement has to be valid. So when we say a valid arbitration agreement, that means key tenets of the Indian Contract Act has to be fulfilled. Second is the consensus ad idem. Consensus ad idem means there is a clear consent from both parties and there's, I'm sorry, there is no uncertainty or ambiguity of words. The parties have clearly consented to submit their disputes to arbitration. If the words are vague, if there is uncertainty that can be interpreted from the choice of language, in that case, consent becomes invalid or void. Second is ouster of jurisdiction. That means any party unilaterally going to court will be referred back to the arbitration. So if the agreement between the parties provide for resolution of the dispute by arbitration and the dispute as such is the subject matter of arbitration, in that case, one of the parties on its own cannot get directly to the court for resolution of the disputes. Even if they go to the court, they will be referred back for arbitration. The courts will not intervene. Next is doctrine of separability. So doctrine of separability comes into picture where, let's say, for certain reasons, the agreement that was entered between the parties is invalid or void. But even in that case, arbitration clause will survive. So the doctrine of separability says that an arbitration agreement, even though contained in a contract, is a separate agreement from the contract itself. So even though it is just a clause, it is treated as a separate agreement. So if for any reason whatsoever, the agreement becomes invalid, the principal contract becomes invalid, still the arbitration clause will survive. And if the clause provides for arbitration, the parties can refer for resolution of dispute through arbitration. Next is the competency to rule on its jurisdiction. So arbitrary tribunal has the capacity to rule on its own jurisdiction, even if it involves a question of validity of the main contract. So even if the question before the arbitral tribunal is whether the main contract is valid or not, that also can be decided by arbitral tribunal. So the AT basically, if you get to see, he has the powers to check the validity or to determine the validity of the main contract without contradicting its own jurisdiction. Now, talking about the requirements of a valid arbitration agreement. So there are certain key requirements that need to be fulfilled to ensure that the arbitration agreement is valid. And these requirements can either be gathered from the statutory provisions, that is the provisions or the sections that had been provided in law, or based on the decided case laws. So the cases that are decided by the courts, and if they provide any requirements of a valid arbitration, that also becomes the requirement. So the first requirement, if you refer to the definition that we read here, it said arbitration agreement means an agreement by the parties to submit arbitration all or certain disputes which have arisen or may arise between them in respect of a defined legal relationship, whether contractual or not. An arbitration agreement shall be in writing. So the first requirement of a valid arbitration agreement is in writing. So arbitration agreements always have to be in writing. It does not necessarily mean it has to be in one single document, but it has to be in writing. There is no specific form or template for an arbitration agreement, but it should be in writing, either on emails. Let's say you get into a contract for supply of chocolates for your office, or supply of coffee from a vendor, right? So you have not entered into some contract with the vendor for the supply of coffee, but the bills that he provides, it says that any disputes pertaining to this transaction will be resolved through arbitration. In that case, it becomes and you have put your signature on that invoice and you have accepted the invoice, then it becomes a arbitration agreement. So I've given you a few examples where how different kind of writing could be considered as a valid arbitration agreement. So you see here, C owns a shop in Chandni Chowk dealing in ready-made clothes. D is a supplier of clothes to C. They have been doing business for many years. No separate written contract exists between them. However, for each consignment, D issues an individual invoice to C on the basis of which payment is made. Each invoice contains the following note: all disputes pertaining to transaction, if any, will be subject to the arbitration rules and regulation of Bharat Merchant Chamber. So what is happening here? This is a arbitration agreement. Another example, if you see, Vikram wants to start a sweet and confectionery shop and contacts Ahuja confectioners and bakers for supply of cakes. The entire communication between the parties took place over email. One of the emails received by Vikram from Ahuja bakers had, among other terms of service, the following condition: any dispute regarding quality or delivery shall be submitted to arbitration conducted under the aegis of Indian Confectionery Manufacturers Association. Please place your order if the above terms and conditions are agreeable to you. Vikram placed an order. The contract stood affirmed by reason of their conduct. So here the consent has been granted through the conduct of Vikram. So this would be a arbitration agreement in writing. So here the arbitration provision is contained in the correspondence between the parties. Is this clear? The requirement of writing is clear. Please say yes or no. Are we good till here, people? So before proceeding further on the remaining requirements of a valid arbitration agreement, I think it's already going to be 8:30. We can take a quick 5 to 7 minutes of break here and then come back again. Is it fine with all of you if we take a break and then join again? Okay, so we will take a quick break of 5-7 minutes and then be here again. So I'll see you guys in another 5 minutes. Okay. Everybody is back on their seats and we are good to resume. Please give me a go ahead. I'm teaching for all of you. If you are not there, what's the point, right? So all of you are back to your seats. 5 minutes break was good enough for everyone. Much needed, right? I know long classes can be tiring at times and you need some time to fathom yourself. Are we good? At least say yes. Drop me a yes in the chat box. Are we going to see students? I'll wait for another 1 minute. I'm waiting to hear a yes from you because else there is no point. Okay, let's begin then. Okay, so we were talking about the requirements of a valid arbitration agreement. So first requirement that we got to see is the thing that it has to be in writing. Writing does not necessarily mean that it has to be a proper structured contract. It could be even as part of a terms and condition on an invoice. It could be as part of a communication over email, telex. So anything which gives a record and can show that parties have consented to it is good enough. But it has to be in writing, that is enough. Just saying that, okay, that day when we spoke to each other, we said ki kabhi ladai, if there is any fight between us, then we can go for arbitration. That is not enough. So writing is a mandate. Second important requirement is a valid arbitration agreement is a consent. So consent has to be a consent ad idem. That is a clear-cut consent where there is no ambiguity, there is no vagueness. So basically the consent of the parties has to be gathered from the wordings of the agreement. So the wordings of the agreement, the wordings of the clause for resolution of dispute through arbitration should clearly specify or should clearly communicate the intent of the parties to resolve their disputes through arbitration. And the wordings of the clause where it merely contemplates the possibility for going for an arbitration is not enough. So the language has to be such that it is clear, crisp, specific, without any ambiguity or vagueness. If there is any sort of ambiguity or vagueness, it will define the purpose. The consent have always to be clear without any confusion. So if you look at this example here, the parties had a contract with a clause 16 that if during the continuance of the partnership or at any time afterwards any dispute touching the partnership arises between the partners, the same shall be mutually decided by the partners or shall be referred for arbitration if the parties so determine. So what do you think? The consent is clear here or not? Is it a clear consent or consent? If you have words here, the same shall be mutually decided by the partners or shall be referred for arbitration if the parties so determine. So there is a language which says if the party so determines. So it can be referred for arbitration if the party so determine. That means still the consent is not clear. It is yet not decided that if there is a dispute in between the parties, it will be referred for arbitration, right? So this need for further agreement between the parties makes this consent vague, correct? Next requirement is that there has to be a defined legal relationship. That means the relationship between the parties has to be for legal activities. Anything concerning illegal activities cannot be submitted to arbitration. The fourth requirement is a final and binding award. So the parties to arbitration agreement must agree that the determination of their substantive rights by a neutral third person acting as a tribunal would be final and binding upon them. So the parties mentioned it in the clause that they will be decided upon the dispute between the parties will be resolved through arbitration, and the decision of the arbitrator shall be binding upon the parties. So if you ever get hands on any contract or pick up contracts online and go through the arbitration clauses, you will see these kind of languages being used there. So if you read here, look at this example. This clause says any other questions, claim, right, matter, thing, whatsoever in any way arising out of or relating to the contract designs, drawings, specifications, estimates, instructions, or orders, or those conditions of failure to execute the same, whether arising during the progress of the work or after the completion, termination, or abandonment therefore, the dispute shall in the first place be referred to the chief engineer who has jurisdiction over the work specified in the contract. The chief engineer shall within a period of 90 days from the date of being requested by the contractor to do so, given written notice of his decision to the contractor. Chief engineer's decision shall be final. Now, what is happening here? It says that the decision of chief engineer is final. The dispute has to be resolved through arbitration. But the only problem here is that the chief engineer is not a neutral third party. He has the control over the work specified in the contract. So always remember, one of the valid requirements are that the arbitrator has to be a neutral third party. He should not be a person who is somehow associated, who has some interest in the matter, or is somehow related to the directly or indirectly related to the project. So this is why there will be a biasness here. Next requirement is specific words. So mere use of words like arbitration or arbitrator in a clause will not make in an arbitration agreement. Usage of such word is not a necessary requirement. So for it to be considered arbitration agreement or arbitration clause, the provision has to be clear and specific. There has to be a clear consent, properly written in writing. The intention should be clear. Just because the word arbitration or arbitrator is mentioned, it does not necessarily become a valid arbitration agreement. Dispute can be in present or it can be in future, that can be subjected to arbitration. Arbitrability. So when we say arbitrability, we are talking about the matter of the dispute. So if you remember, I was telling you, we can either refer all disputes pertaining to a contract to arbitration, or we can specify the set of disputes that need to be arbitrable. So if a dispute has to be decided by arbitration, it should be a subject matter of arbitration. So the dispute proposed to be submitted to arbitration must be arbitrable. There are certain disputes that the law retains exclusively for the court, and the same cannot be submitted for arbitration. So there are always certain set of disputes that can never be decided by arbitration, like criminal offenses, matrimonial disputes, guardianship matters, partition disputes, testamentary affairs, mortgage suits, sale of a mortgage property. All these cannot be arbitrated. These will always be decided by the court. So the matter of dispute should be such that is arbitrable in nature. So if you look at this example here, the parties agreed to refer the question of winding up of a company to arbitration. So first tell me, is winding up of company is even a prerogative of arbitration, or it is a decision of a company law tribunal? So the power of winding up lies with the company tribunal, right? So arbitrator will not have a jurisdiction to wind up a company. So the court cannot make a reference for arbitration here. Correct. So the matter for arbitration should always be one that can be arbitrated. I didn't get your question, Pradeep. But in writing point mentioned only agreement in writing. Yes, the agreement has to be in writing, but the consent is also a valid requirement, right? What is your concern? I didn't get your question. Sorry. Reframe your question so that I'm able to answer it better. Okay, coming to the next requirement, which is signature. So signature is required only when the arbitration clause is contained in a contract where there is a correspondence or exchange of pleadings. Their signature is not a mandate. So here is a sample arbitration clause that, okay, before I proceed on to a sample arbitration clause, Pradeep is asking me, ma'am, what is the difference between writing and specified word point? So when I say that the arbitration agreement has to be in writing, that means it has to be written. The records has to be retrievable. When I say that the mentioning of the specific words like arbitrator or arbitration does not make it a valid arbitration agreement, that means just because these words are mentioned in a clause or in an agreement, it does not become a valid arbitration agreement. It will be a valid arbitration agreement only when the consent of the parties are also clear, right? They are ready to subject their dispute and the matter is arbitrable. So just mentioning of the word arbitrator or arbitration does not make it a valid arbitration agreement. Consent also has to be clear. The matter should be subjected to a neutral third party. All the other requirements also needs to be met. This is what is meant there. Is that clear? The difference between writing and specific word point? I hope I was able to address your concern. I haven't received your reply yet. Anyways, I'm proceeding further. So here there is a sample arbitration clause that I have included here. This is not given in your study material. This is only for you to help understand how arbitration clauses are structured in real life basis. So this is from one of my contract that I have drafted. So it says, any and all claims, disputes, questions or controversies involving the parties and arising out of or in connection with this agreement or the execution, interpretation, validity, performance, breach or termination hereof, collectively disputes that cannot be finally resolved by the parties within 30 calendar days of arising of a dispute by amicable negotiation and conciliation shall first be submitted for settlement by informal arbitration to an arbitral panel consisting of the senior official of the shareholders and the company. If such panel negotiation in good faith is unable to resolve and settle the dispute within 60 calendar days after the dispute is first submitted to it, then any party shall be entitled to cause the disputes to be settlement for pursuant to 37B. So if you see, there are tier-wise mechanism for resolution of dispute. First option is that the disputes has to be resolved amicably between the party within 30 days of the arising of dispute. Now, if the parties are not able to resolve the dispute amicably, the senior officials and the shareholders of the company will form an arbitral panel and they will informally try to resolve the dispute. So see, even though the word arbitral panel has been used here, that does not mean that they will be going into proper arbitration. It also says that it has to be resolved informally through negotiation. So if this panel, and because shareholders and the company senior officials are directly involved, are the stakeholders, or they are directly involved, they can never be the neutral third party or the arbitrator. So what is happening? This is also an informal way of resolution of dispute. So it says that if shareholders of the company are also not able to resolve the dispute within 60 days, then it will be settled as per the provision given under 37B. Now, what does 37B says? It says any dispute which is not settled to pursuant to 37A shall be referred to a panel of arbitrators consisting of one arbitrator. So what has it done? It has defined the number of arbitrator required. So the clause says it requires one arbitrator. Now, usually people go for sole arbitrator because to every arbitrator you have to pay fees. So if there are 3 arbitrators, you will have to pay them. So the cost of arbitration will be 3 times. So here it says that the panel of arbitrator consisting of one arbitrator appointed by the petitioner in party or parties, as the case may be, one arbitrator appointed by the respondent party or respondent. So what has he said? If there are 2 parties to the agreement, one petitioner will Okay, so what is it saying? That one arbitrator will be appointed by the petitioner, the person who has submitted the dispute. The second arbitrator will be appointed by the respondent, the person who is replying to the dispute, or respondent, as the case may be. And both the arbitrators shall appoint the presiding arbitrator, and the arbitration shall be conducted with the Indian Arbitration and Conciliation Act 1996 as amended from time to time. The venue of arbitration shall be Hyderabad. So this is how generally you get to see structuring of sample. So they have technically provided for 3 arbitrators. There are a lot of arbitration clauses where you will see that one sole arbitrator will be mutually appointed by both the parties. And if the sole arbitrator is not appointed within 30 days from the mentioning of the dispute, then the court, the parties can, the arbitrator will be appointed by the court of the respective jurisdiction. This is how you get to see arbitration clauses in. Is this clear? Are we good till here, guys? Any confusions till here? Any queries? Any questions? These are just the basics that we are talking about as of now. Next is arbitration agreement through ref. So here we are talking about a situation where there could be a reference for arbitration to another contract. So this is called arbitration agreement through reference, but this reference should be such that it does not create any confusion in the mind of the reader, and it should clearly convey the intention of the parties to incorporate the arbitration agreement into the agreement between them. So let's say today we are A and B is entering into a contract. A year back also they had entered into a contract for supply of iron rods. Today they are entering into a contract for supply of iron sheets. Now they may refer to the previous contract for arbitration, but the language in today's contract should be such that it does not create any confusion. It should clearly convey that the parties were willing to incorporate the arbitration agreement into the agreement between them. So that clause from the older agreement will be considered as a part of this agreement. This is what is an arbitration agreement through reference. So if you look at this example here, in Group Chimique Tunisian SA versus Southern Petrochemicals Industry Corporation Limited, the respondent had placed an order of purchase of various quantities of phosphoric acid from the petitioner. So who is the petitioner here? Group Chimique Tunisian is the petitioner. Southern Petrochemical is the respondent. So in civil suit, the person who raises the dispute is the petitioner, who replies to it is called the respondent. The purchase order noted that the terms and conditions were to be as per the Fertilizer Association of India terms and conditions for sale and purchase of phosphoric acid. Clause 15 of the terms provided for settlement of dispute by arbitration. Now the question is this a valid reference for arbitration agreement to come into existence? So Supreme Court held that for a reference to constitute an arbitration agreement, the contract should be in writing and reference should be such as to make that arbitration clause a part of contract. So both the conditions were held to be fulfilled in present instance, because the TNCs of the Fertilization Association of India is also in writing, and the parties clearly mentioned that the TNC of the sale were to be as per the TNC laid down by the Fertilizer Association of India. So this was a valid arbitration agreement through reference. Is this clear? Everybody, arbitration through reference is clear to all of you? Say yes or no. I don't get a feeling that whether my students are attentive or not. I have that because I'm not in front of you. When I'm in front of students delivering a physical class, I get to see the faces of students. Here I'm totally dependent on your communication with me in chat boxes. So there is no point now when students are not a part of the class, they are not responding. It becomes really sad to teach like that. So are we good till here, students? Things that we have discussed, the concept of agreement through referencing is clear to all of you. And there's no confusion. These are just very, very basic concepts that you are being taught in your syllabus. And these are definitely going to help you when you become professionals. So these are key concepts that everybody should know, especially the professionals who are working in this industry. So there's nothing fancy that is being taught to you as of now. No details. Details are being handled by the lawyers generally. Is it clear? Okay, so let's proceed further. Now talking about the termination of the termination of an arbitration agreement. What are the different situations under which an arbitration agreement can be terminated? So the first thing is a mutual consent, where both the parties mutually agree to terminate their arbitration clause. Second is if the principal contract is terminated by way of discharge or novation. So where the principal contract which contained the clause for arbitration is completed, either the obligations has been completed or it has been replaced by a new contract, in that case, arbitration agreement is terminated as well. But if the principal contract is breached, then the arbitration agreement will survive. So you will generally see that the contracts contain the provision that when there is a breach of contract, this contract will be terminated. So if the termination is happening, if the termination of principal contract is happening because of the breach of contract, in that case, doctrine of separability will come into picture and the arbitration clause will survive. So if you look at this example here, Raj Air Conditioning Services and Voltas Limited entered into a service agreement whereby Raj Air Conditioning Services would provide annual maintenance services for all Voltas commercial air conditioners in the NCR region. The contract provided that in the event of a dispute between the parties, the matter would be submitted to arbitration. So the first scenario is at the end of the third year, the service agreement was not renewed. The contract terminates. So because the service agreement was not renewed, the principal contract is being terminated because of completion or non-renewal, and the arbitration agreement will also terminate. Second situation is at the end of the second year, the two parties enter into a non-new contract which replaces the existing service agreement between the parties. Now this new contract neither has an arbitration clause nor does it cross-refer to the previous arbitration agreement. So neither it has arbitration clause nor it refers. So in this case also, the arbitration agreement will be terminated. Now the third case is Voltas raises a dispute with RACS regard quality of services and terminates the agreement. So here the termination is happening because of the breach of contract. The parties to the contract has not fulfilled the terms and conditions as provided, or they have failed to discharge their liabilities or responsibility as per the terms of contract, leading to a breach. So here doctrine of separability will come into picture. Even though contract has been terminated, the dispute resolution clause or the arbitration clause will survive, and the parties will be able to resolve their dispute through arbitration. Is this clear? This is important scenario that we have case application based questions from these case studies and similar examples. Is this clear? Any confusion in this example regarding termination and survival of arbitration clause? Please let me know if there is any more confusion here. Okay. So proceeding further, next is death. So death does not terminate the arbitration agreement. It becomes enforceable by or against the legal representative of the deceased. And legal representative in this case means a person who in law represents the estate of a deceased person and includes any person who intermeddles with the estate of the deceased, and where a party acts in a representative character, the person on whom the estate devolves on the death of the party so acting. So let's say after the death of the father, the estate devolves on the son. So if a lawyer is representing the son, he becomes a legal representative. The son is also the legal representative because he is the person on whom the estate has devolves after the death. So by death, the arbitration agreement is not comes to an end. It is enforceable by or against the legal representative. Correct? Next is operation of law. So an arbitration agreement can be extinguished by the operation of law, by virtue of which any right or right of action is extinguished. So there are certain situations where the law comes into operation and the arbitration agreement does not, or the arbitration agreement gets extinguished. Is that clear? So basically there are four things that we discussed. One is mutual consent. Second is termination of principal contract. Third situation is death, but death does not terminate the arbitration agreement. And fourth is the operation of law. So these were four key points regarding to the termination of arbitration agreement. Are we good till here? So proceeding further, let's quickly proceed on the next part. Now talking about arbitral tribunal. So arbitrators or arbitral tribunal, they perform the function of a judge that we very well know. So these are the people before whom the parties present their disputes, submit their evidences, produce witnesses, and then arbitrator in turns apply the law and his knowledge to decide upon the dispute. So these are very much similar like the public functionaries called the judges. Now this word arbitrator or the arbitral tribunal is interchangeable. Whether it is one arbitrator or more than one arbitrator, it will be considered as a arbitral tribunal. Now, there is a unique feature of arbitration where the parties get to select their arbitrator, or they delegate it to an institution like FICCI, ICC, ICADR. So these are the bodies who are institutions of arbitration. So when the arbitration is referred to the institution appoints the arbitrator on behalf of the parties. But as such, the appointment and termination of arbitral tribunal is regulated by the Arbitration and Conciliation Act. And there are different provisions and possibility that has been provided for, which can lead to appointment or removal of arbitral tribunal. And there are different authorities which have the power for appointment and removal of the arbitrators from the tribunal. Okay. Now the first question arises, who can be an arbitrator? So if you look at the law does not prescribe any specific qualifications for being an arbitrator, but a person who is above 18 years of age and of sound mind, he can be appointed as arbitrator. That means he must be capable of entering into a contract. So any person who is capable of entering into a contract can be appointed as an arbitrator, right? So it can be people from different fields like engineering, people from scientific backgrounds, people from management backgrounds, people who are responsible for project management, who are responsible for huge high-stake projects which are of 1,000 CRs, 5,000 CRs. So all these people are capable of becoming arbitrator. The only requirement is that they should be capable of entering into contract, right? So generally, if you look at the institutions, they have a panel of arbitrators. And such institutions also include foreign arbitrators, so that if there is a foreign parties, they are comfortable in choosing the arbitrator of their own nationalities. Another thing is that the arbitrator necessarily should not be a lawyer. They can be non-lawyer as well, but they are the experts of their area. Now, why do we need such experts, and why can't just lawyers take care of it? Because lawyers are the expert of law. They understand the legal procedures, what is written and provided for in the law. But the technical terminologies or legal technical jargons that are used in the contracts specific to an industry, that can only be understood by a technical expert. The expert in that particular field, they understand how a particular field is functioning or how the work is executed and what are the nitties and gritties associated with execution of work in a particular field. This is why we need people who have expertise in different areas. The next thing is that the arbitrator has to be impartial and neutral to the dispute, and he has to be independent to the parties. If he is in any way related to the parties, he cannot be appointed as a tribunal because there will be an obvious biasness, right? Now, when we talk about appointment of arbitral tribunal, the parties have been given a autonomy. The parties have a freedom to choose the procedure for appointment of arbitrator, the venue of arbitration, the seat of arbitration, and also to decide on who the arbitrator will be or who the person would be who will be adjudicating upon their disputes. However, in terms of number of arbitrator, there is section 10. So section 10 says, section 10 of the Arbitration Act says, the parties are free to determine the number of arbitrators, provided that such number shall not be an even number. Failing the determination referred to in subsection 1, arbitral tribunal shall consist of a sole arbitrator. Now, if you read section 10, it specifically says that it could be any number of arbitrators, but it shall not be an even number. Now, what is the reason for providing that the number of arbitrators should not be even number? So under arbitration, the decisions are always taken through majority, right? So let's say there is a dispute on which let's say there are two arbitrators and they have different opinion. How will the decision be made? But when there are three arbitrators and there are two decisions, he will be in favor of either one of the decisions, right? He will not be able to favor both the decisions. So the decision making becomes easier whenever there is a deadlock. This is why the section says that if the number of arbitrators should not be even, they should always be odd, like 1, 3, 5, 7, 9, like that. But there was a landmark case called Narayan Prasad Lohia versus Nikunj Kumar Lohia. In this case, Supreme Court held that even number of arbitrators is an acceptable possibility. So through this case, it has been permitted that it is permissible to have even number of arbitrators as well. Now, the Supreme Court says, among the many reasons put forward, the court observed that it was possible that the two arbitrators may not disagree, in which case there would be consensus and no disagreement. Also, it was not correct to permit parties to proceed with the arbitration and raise objection only when the decision goes against them. Thus, after this decision, it seems that the parties can choose even number of arbitrators. However, in practice, this rarely happens because it is most of the times, if it is smaller contracts with low value, you will usually see sole arbitrator. And where there are very, very high stake of contracts, which involve some like 1,000 crores, 2,000 crores, something like this, or 500 CR, there usually you will get to see 3 arbitrators. This is what a general practice that you usually get to see in the market. Now, talking about the procedure for appointment of arbitrator. So again, there is no strict procedure or guidelines for appointment of arbitrator. It can be a simple method or the complex one, as whatever one feels comfortable. But generally, if you see, if the arbitration clause provides for sole arbitrator, in that case, you will generally see that the clause would say one sole arbitrator to be mutually appointed by the parties. And we as lawyers always recommend that there should be a timeline for every procedure that has been included or every step. So let's say sole arbitrator to be mutually appointed by the parties within 30 days from the mentioning of the dispute. So because if the arbitrator is not appointed within 30 days, you can reach out to the court. Else a lot of lingering happens and a lot of time is wasted. So the objective of arbitration was also speedy disposal. So because the parties have autonomy here, it is important to have timelines in place so that there can be speedy disposal of disputes. Second situation you get to see is that where there is a 3 arbitrator or 5 arbitrator. So when there is 3 arbitrator, usually both the parties appoint 1 arbitrator each. And these 2 arbitrators that have been appointed, they mutually appoint a 3rd arbitrator. Or similarly, where there is a requirement for 5 arbitrators, both parties appoint 2 arbitrators each, and these 4 arbitrators together appoint a 5th arbitrator. This is what is generally that is followed and that is widely rampant in the industry. So you pick up no matter how many contracts, generally this is the procedure that you will get to see in those contract. Is that clear? But we always have to ensure that the person who is being appointed as an arbitrator, he is an unrelated person or institution. There should not be any direct connection. The person should not have been an employee, or he should not be directly involved with the project. He should not be a party or should be a party of interest in the dispute. So these kind of scenes should not be there. So this is the general procedure that I have described. However, there can be other scenarios. The first scenario is where the parties are not able to decide on the appointment procedure. Or there can be other scenario where parties have decided upon a procedure, but procedure requires action, but the party or the arbitrator or institution fails to act as required under the procedure. So there are 2 situations. One is they are not able to finalize the procedure for appointment of arbitrator. Second is procedure has been provided for in the arbitration clause, but they are not able to act upon it. So let's say procedure says that the parties will, on mutual consent, jointly appoint an arbitrator who has expertise in the area of contract management. Right? Supposedly, this is the term of the contract. Now, the parties mutually are not able to narrow down a common name to which they both agree. So what is happening? They are not able to execute or take actions upon a procedure. In that case, what will happen? So here, Section 11 of Arbitration and Conciliation Act comes into picture, which provides for
alternate procedures. So section 11 says a person of any nationality may be an arbitrator unless otherwise agreed by the parties. So you see, again, there is a autonomy. So the agreement clause can say that the arbitrator expert having expertise or 10 years of experience in the field of contract management and who is of Russian origin will be appointed as an arbitrator. Is it a valid arbitration clause? Yes, it is. So the parties have free will to decide on the kind of arbitrator they want. They can decide on the nationalities. They can also provide a list of names amongst whom it can be decided. So there are arbitration clause which says that the parties have to mutually appoint an arbitrator from the list of arbitrators appended to the agreement. So there will be a list containing 6, 7, 8 names. So parties can mutually decide on a name. So there are all sorts of twists and turns and options available in terms of the appointment of arbitrator. Further, section 11 says, subject to subsection 6, the parties are free to agree on a procedure for appointing the arbitrator or arbitrators. Failing an agreement referred to in subsection 2, in an arbitration with 3 arbitrators, each party shall appoint 1 arbitrator and the 2 appointed arbitrators shall appoint the 3rd arbitrator who shall act as the presiding arbitrator. So let's say the requirement in the arbitration clause is for 3 arbitrators and all the 3 arbitrators have to be appointed mutually, right? That is one option. Second is that the arbitrators are 3 that is required, but the parties are not able to decide on the procedure on how they will be appointed. So if they are not able to decide on the procedure and if there are 3 arbitrators, each party will appoint 1 arbitrator and those 2 arbitrators will appoint a presiding arbitrator. 4th subclause says, if the appointment procedure in subsection 3 applies and a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so from other party, or the 2 appointed arbitrators fail to agree on the 3rd arbitrator within 30 days from the date of their appointment, the appointment shall be made upon request of a party by the Supreme Court or the High Court or any person or institution designated by such court. So if it is an international commercial arbitration, the appointment will be made by Supreme Court or a person designated by the Supreme Court. If it is a domestic arbitration, the appointment will be made by High Court or an institution designated by High Court. So the High Court can say that ICC will appoint the arbitrator on their behalf. It is permissible. So what has happened? The law does not only prescribe the procedure where the parties are unable to decide on it, but it also provides a timeline. So let's say where there is a requirement for 3 arbitrators and the parties are not able to agree on the procedure for appointing the arbitrators. In that case, each party will appoint 1 arbitrator each. The 2 appointed arbitrators are to appoint a 3rd arbitrator who will act as a presiding arbitrator. Now, if the parties fail to appoint an arbitrator within 30 days from the receipt of request to do so, any of the party can reach out to court for appointment. Where the 2 appointed arbitrators are unable to decide on the 3rd arbitrator within 30 days from the date of their appointment, 30 days from the date of their appointment, please be careful with the words, 30 days from the date of their appointment, then also the appointment can be made High Court or the Supreme Court as the case may be, upon the request of the party. And the High Court and Supreme Court can either themselves appoint the arbitrator or they can instruct an institution designated to appoint an arbitrator. Is this clear? Guys, is this clear? Section 10 and 11 is clear to all of you? Please let me know, it is an important section. Okay. Further, subsection 5 says, failing an agreement referred to in subsection 2 in an arbitration with a sole arbitrator, If the parties fail to agree on the arbitrator within 30 days from receipt of a request by one party from the other party to so agree, the appointment shall be made upon request by a party by the Supreme Court or the High Court or any person or institution designated by such court. Again, there is a timeline that has been provided in case of sole arbitrator also. So if the parties are unable to decide on the procedure and a sole arbitrator has to be appointed and 30 days has passed, in that case, the party can reach out to the court. Now, where under an appointment procedure is agreed upon by the parties, a party fails to act as required under that procedure, or the parties or the two appointed arbitrators fail to reach an agreement expected of them under the procedure, or a person including an institution fail to perform any function entrusted to him or it under that procedure, then a party may request the Supreme Court, or as the case may be the High Court, or any person or institution designated by such court to take the necessary measure unless the agreement on the appointment procedure provides other means of securing the appointment. So everywhere, if you look at the language of the law, it always gives a freedom, a free will, and autonomy to decide on the procedures. So either the procedures have to be laid down in the arbitration agreement, in the arbitration clause, or they will be governed by the Arbitration and Conciliation Act, Section 11. Further, subsection 6A says, the Supreme Court or the High Court, while considering any application under subsection 4 or 5 or 6, shall, notwithstanding any judgment, decree, or order of any court, confine to the examination of the existence of an arbitration agreement. So it is important that they ensure that the arbitration agreement in place. The designation of any person or institution by the Supreme Court, or as the case may be the High Court, for the purpose of this section shall not be regarded as a delegation of judicial power by the Supreme Court or High Court. So because an institution is appointed by the Supreme Court or High Court for appointment of arbitrator, this will not be considered as a delegation of judicial power. A decision on a matter entrusted by subsection 4, 5 or 6 to the Supreme Court, as the case may be, or High Court, is final, and no appeal, including latter's patent appeal, shall lie against such decision. So once the appointment is made either by the Supreme Court or the High Court or the designated institution, there is no appeal against that. So if the Supreme Court or the High Court appoints the arbitrator, you have to stick by that. Subsection 8 says, the Supreme Court, or as the case may be, the High Court, or the person or institution designated by such court, before appointing an arbitrator, shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12, and have due regard to any qualification required for the arbitrator by the agreement of the parties, the contents of the disclosure and other consideration as are likely to secure the appointment of an independent and impartial arbitrator. So under section 11, the court takes a disclosure in writing. So when the court is also appointing the arbitrator, if the arbitration clause provides for certain specific requirements, expertise, or qualification of arbitrator, court takes it into consideration, and they take a disclosure so that they can ensure that a impartial and independent and an unbiased arbitrator could be appointed. So, if you talk about appointment of arbitrator by parties, it is provided for section 11, 2 and 3, and by court is given under 11, 4, 5 and 6. Is this clear? So here I have discussed the scenarios that I have explained. So if the number of arbitrator is 1, party 1 and 2 jointly appoint the sole arbitrator. If the number of arbitrator is more than 1, let's say 3, so party 1 will appoint arbitrator A, party 2 will appoint arbitrator B, and they together will appoint the presiding arbitrator. So there is an example that I provided for you here. When a joint appointment was required, party 1 sent the following names to party 2: Sunil, Peter, Meenakshi, Iqbal and Anil. None of them was acceptable to party 2. which sent the following names to party 1: Akram, Shamik, Sebastian, Aarti, Devashish. From this list, party 1 was agreeable for Shamik and informed party 2. So what has happened? Both the parties have mutually been able to agree on a common name, and Shamik would be considered to be jointly appointed as an arbitrator. Now, if you look at this another example, when 3 arbitrators were to be appointed, party 1 selected Sunil as their arbitrator, party 2 selected Iqbal as their arbitrator. The 2 arbitrators then jointly discussed the following names: Shamik, Peter, and Meenakshi, out of which they selected Meenakshi as the third presiding arbitrator. Similarly, where there were 5 arbitrators, each party will appoint 2 arbitrators each, and 4 will together appoint the presiding arbitrator. So this is one of the scenarios. Second scenario is that even though the parties have agreed on the procedure to appoint an arbitrator, they are not able to do that. So they do not either reach idiom, consensus idiom, or they are not able to do that. So if you look at this example, if according to the agreed procedure, the appointment of arbitrator was to be made by the ICADR, which is International Center for Alternative Dispute Resolution, but such an appointment was not made, then this situation will fall under scenario 2. In this case, the party will have to approach the court, High Court or the Supreme Court, as the case may be, and request for appointment of arbitrators to the court under the Arbitration and Conciliation Act. And once the arbitrator is appointed by the court, there is no appeal against that. Okay? So for the designated authority, we remember for international arbitration is the Supreme Court. For domestic arbitration, it's the High Court. Always remember that for the appointment of auditors, the authority that we say, when it is an international arbitration, it will be the Supreme Court. When it is a domestic arbitration, it will be the High Court with the respective jurisdiction. So let's say if the parties are from Delhi, it will be High Court of Delhi. If the parties are from Mumbai, it will be the High Court of Mumbai. So the territorial jurisdiction has to be taken into consideration in terms of which High Court will appoint the arbitrator. And all these things are generally taken care by the lawyers themselves. Are we good till here? Everybody, are we fine till here? Any questions, any queries, any concerns till here? We can have 5 minutes for discussing the queries, because there's no point jumping on the topics with questions lying behind in your thoughts. You will be lingering upon those questions only. So we can have 5 minutes to discuss if you have any queries or concern till here. Please let me know if there are any queries for the topics that we have already discussed till now. So Sumit is asking me, ma'am, if one party is from Rajasthan and another party is from Maharashtra, when they would be signing the contract, they would mention, so there's a clause in the contract which talks about law and jurisdiction. So it says that the jurisdiction of which state or the courts of which state will have jurisdiction. So if it says that the courts of Rajasthan will have jurisdiction, in that case, the application will be made to the High Court in Rajasthan. And if it says that the jurisdiction will lie with Maharashtra, then it will be made to the High Court of Mumbai. Is that clear? So it all depends on the choice of law and jurisdiction that the parties have made. A lot of times you will get to see when the parties are two different states, they choose a neutral third jurisdiction, because when they choose, let's say Rajasthan the party from Rajasthan will say choose Rajasthan, party from Maharashtra will say choose Maharashtra. So they'll say let's not keep it Rajasthan or Maharashtra, let's keep it Delhi, so that both have to put in equal effort. If the court has appointed the arbitrator, there is no appeal against the appointment of arbitrator. But if later on it is found that after the appointment of arbitrator, it is found that he's partial, it is biased, or he is doing some sort of favor to either of the parties, in that case, the appointment of arbitrator can be challenged in court. So making an appeal against the appointment of arbitrator is different from challenging the appointment of arbitrator on grounds of biasness and impartiality. Or also remember that arbitration is a procedure which provides for minimal invasion and interference of court. This is why we have arbitration. If for everything there has to be appeal in the court, there is lingering upon the matter, then how will you achieve speedy disposal of disputes also? No? That is another reason. That is why there are very strict timelines, strict procedures for that. For everything, there is not appeal. You just cannot keep on delaying the matter and dispute by going on appeal in courts. This is why. Is that clear, Pradeep? Any other question here? Please let me know if there are any queries, only then I will proceed. Please let me know if there are any questions here on the topics that we have already covered. I'll tell you, there was one of the recent cases, which is NN Global Mercantile Private Limited versus Indo-Unique Flame Limited. So in this case, the question before the court was that whether an arbitration agreement would be enforceable if the underlying contract was not properly stamped. So here the Supreme Court said that the arbitration agreement is the independent agreement between the parties and is not chargeable to payment of stamp duty. So let's say if there is a commercial contract on which the stamp duty has not been paid, still the arbitration agreement would stay valid. This is one of the recent cases that was decided by the Supreme Court in 2021, I suppose. So you will see a lot of matters presently being resolved through arbitration, and a lot of judgments are also on and off coming into picture that gives us a better understanding on it. Any more questions? Okay, so let us proceed further. So there was this case, as I told you, that it is one of the landmark judgments, which is SBP and Company versus Patel Engineering Limited. In this, the Supreme Court observed that once the appointment has been made by the appointing authority, it could not be challenged before the arbitral tribunal or any other court. Until and unless later on the biasness or something comes into picture, then it is a separate story. Now, this is just the summary of what I discussed, that if the parties failed to appoint an arbitrator in accordance with the agreed procedure, or parties had not decided on a procedure to appoint an arbitrator, then the parties will proceed according to the procedure noted in the Act. And if the parties fail to follow the procedure given in the Act, they will approach the court. Now, the court will require the parties to act in accordance with the agreement, or they will themselves appoint the arbitrator. When the arbitrator is being appointed in court, they will ensure that the qualifications are taken care of and biasness is ensured. This is why they take a disclosure in writing, right? Is that clear? So if you remember, if you make a disclosure to court in writing and it later on comes to be a lie, there can be strict actions against the person who has given things in writing to the court. Okay. So let's talk about the requirements of an arbitral tribunal. The first thing is that he can be of any nationality until unless there is some specific nationality specified in the arbitration agreement. Second is the tribunal should be capable of entering into a contract. They should not be disqualified under Indian Contract Act. Third should be, they should not be biased, act independently and impartially. Now, when we talk about biasness could be a pecuniary bias, a personal bias, or bias as to subject monitor or policy bias. Now, there was this case, which is Ranjit Thakur versus Union of India. In this case, the Supreme Court laid down the test of biasness. So the court held that the test of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely and the matter was likely to be disposed in a particular way. Because under section 18, biased outcome is not an outcome under law. So biasness is something that should not be there. So there are a lot of suggestions that have been given in Schedule 5 and 7, which lays down situations under which a biasness can be assumed, right? So neither there should be biasness, nor there should be a dependence, and there should also be a impartiality. So when we say independence, we say there is a lack of relationship between the arbitrator and party. Like if there is previous employment, then the arbitrator would lack independence. Impartiality is the lack of state of mind or arbitrator. That means if the arbitrator is favoring a particular party, that means he is not impartial. So the arbitrator is supposed to be unbiased, act independently, and be impartial. Because if any of these things are present, then the appointment of arbitrator can be challenged. So section 12 says, when a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances such as existence of either direct or indirect of any past or present relationship with or interest in any of the parties or in relation to the subject matter in dispute, whether financial, business, professional, or other kind, which is likely to give rise to doubts as to his independence or impartiality. So whenever a person is approached as appointment for arbitrator, he has to give a disclosure in writing. Disclosure in terms of his present or past relationship, whether it is financial, business, professional, or any other kind of relationship that can raise doubts as to impartiality and independence. B, which are likely to affect his ability to devote sufficient time to the arbitration, and in particular his ability to complete the arbitration within a period of 12 months. So let's say he's a full-time employee, senior employee in Indian Oil. Do you think he'll be able to take out sufficient time for arbitration and able to complete the arbitration in 12 months? No. So if there is any kind of work or he is devoted in some other work, then he has to make a disclosure to that. Along with that, there are certain grounds that have been given in 5th schedule that guide in determining whether circumstances exist which give rise to doubt as to independence or impartiality. And this disclosure that is required, that has to be made in the form that has been given in the 6th schedule. Is that clear? Now, if you look at this example here, Anil, who is a chartered accountant with his own independent practice, is the arbitrator in an arbitration between Tata Inc. and Suzuki Limited. Now, first situation is, prior to starting his practice, Anil had worked for 5 years with Tata Tea. In this situation, the law would deem Anil to be lacking independence because he was an employee. So there is a chance of his biasness. Situation 2, during the proceedings before the arbitral tribunal, Anil would allow Tata Tea to take many liberties, for instance, taking as much time for making oral arguments, cross-examining the witness, for submitting the documents, etc. Also, the proceedings were adjourned and whenever requested by Tata Tea. When Suzuki Motors wanted to take extra time, they were not allowed. In few instances, when they were permitted, they were asked to pay heavy cost to Tata Tea for delaying the proceedings. This would be a case where the arbitral tribunal clearly favors and is partial. Therefore, the tribunal lacks the impartiality here. So in this case, the appointment of our arbitral tribunal can be challenged in front of the court. So it becomes one of the grounds for challenging the appointment of arbitral tribunal. Second example, if you see, Party A knew that Vikas had been an employee of Party B. So what's important here? Knew. There is knowledge. Party A knew that Vikas had been an employee of Party B. Yet, it goes ahead and appoints or agrees to the appointment of Vikas as arbitrator. So let's say there is a situation where the person who is going to be appointed as an arbitrator is already given a disclosure of his interests or of his employment, which can raise concerns of biasness. Even then, if the parties mutually agree to appoint him as an arbitrator, then his appointment cannot later be challenged. Party A cannot later challenge Vikas on the ground that he had been an employee of Party B. It can, however, challenge him on other grounds which had not been disclosed by Vikas. So his challenge can still be made, but not on the ground that he had been an employee of Party B, because they were aware, they had knowledge, and willingly, with knowledge, they decided to make an informed choice. When such an informed choice is made, law respects that choice and enforces that choice. So once one cannot take benefit of his own wrong. So it was a choice that is made with a conscious decision with all the knowledge. So later on, he cannot question the conscious decision just because an award was against him. This is what is meant here. Is this clear? Is this clear, guys? So even though there might be previous connection between arbitrator and one of the parties or person, previous behavior might have raised doubts as to their impartiality. However, it does not prevent parties from appointing that person as the arbitrator. So parties have full autonomy to waive off any objectionable grounds and make the appointment. However, once appointed, the party that made or agreed to the appointment cannot raise a challenge on the same ground, but they can raise a challenge on a new ground. So there are some of the instances which I've shared here that can give rise to doubts as to present or biasness, like arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with other party. Arbitrator currently represents the lawyer or law firm acting as counsel for one of the parties. So let's say I am the lawyer for party A and the arbitrator represents my law firm. So that case also can raise the doubts as to biasness. Now this, if you are, when the appointment is being made, this disclosure has already been made to the parties. And even then, if I am appointed, in that case, my appointment cannot be challenged on this ground. So it is the choice of the parties that whether they take it as a biasness or they are okay with this. Arbitrator has given legal advice or provided an expert opinion on the dispute to a party or an affiliate of one of the parties. A close family member of the arbitrator has a significant financial interest in one of the parties or an affiliate of one of the parties. Arbitrator is a legal representative of an entity that is a party in the arbitration. Arbitrator has a significant financial interest in one of the parties or the outcome of the case. Arbitrator has previous involvement in that case. So these are all several instances under which the question of biasness comes into picture. Is that clear? Any doubts still here? We have completed quite a lot of topics today. So any doubts still here? Please share your questions. Any queries and concerns still here? You get to see case study based questions on these grounds. So let's say if after disclosure of biasness, if the appointment is made, can it be challenged? No, it cannot be challenged. So these kind of things you have to always remember. Is this clear? Any other question that you have on the topics that we have completed till now? Should we proceed further? There are only two reasons on why I'm not getting a query. Either there are very few students who are attending the class live today, or it's just that I'm teaching too well. What's happening? Very little queries that I'm getting on this topic today. Usually students have a lot of questions on this. Any further questions? Okay, I think the topics that we have covered is clear to all of you. We can proceed further. Now, next thing that we have to talk about is the duties and liabilities of the arbitrator. So first is that they have to conduct the arbitral proceedings without any delay. So unnecessary delays in submission of documents or examining of witnesses or the recording of statements should not be there. Second, because the entire arbitration proceedings have to be completed within a period of 12 months. Second is, he must remain impartial. That is, both the parties should be treated equally and there should not be a biasness. The contents of the arbitration have to be kept strictly confidential. No party other than the parties to the arbitration should be made aware of any matters concerning the arbitration. Fourth is deliberation. So the arbitral tribunal, before arising on a conclusion or a decision, should properly discuss the issues at hand, consider the evidence that have been put forth, and then they should give a reasoned award. The arbitral award that is passed by the tribunal should always be associated with a reason. They should come down to the conclusion with a reasoning on why did they come to the conclusion. So the arbitral award would say something like this, that based on the evidences in so and so and this conclusion has been arrived. And the award is always achieved through majority. So where there are 3 arbitrators, either all the arbitrator would agree to it, or it will be 2 arbitrators. So as per law also, there is a requirement for signing of the arbitral award. So if the majorities agree to the decision that has been made, the signing also has to be done only by the majority party. Second is avoid unilateral communication with one party. So any of the instances where the arbitrator is speaking separately to one of the parties and not informing other arbitrators or other party about this communication, or meeting out of the arbitration room to the parties. So this kind of unilateral communication should be avoided because it raises concern of biasness or favoritism or partiality. Next is ensure all documents and communication received from one party is communicated to the other party. So whenever certain documents, invoices, agreements, recordings, anything, if it is submitted to by one of the party to the tribunal, the same needs to be served to the other party. So they are aware on what are the evidences that are going on in the dispute. Next is ensure that the award and all other decision comply with legal requirements. So the award should comply with the legal requirements, else it would not be enforced. Next is he or she should ensure to comply with legal requirements associated with the arbitrator. So if the legal requirements is not maintained, the appointment of arbitrator will be challenged and the entire process will turn futile. Next thing is termination, removal, and substitution of arbitral tribunal. So before we go on that, duties and liabilities of the arbitrator is clear to all of you. Any questions on duties and liabilities? Please let me. Is it clear? So I'll quickly repeat it for you in short. First thing is the arbitral proceedings have to be conducted without any delay. The arbitrator has to be impartial at all times. The information regarding arbitration has to be kept confidential. The award has to be reasoned and achieved through majority. Unilateral communication should be avoided. All documents and communication received from one party should be communicated to other party. Award and all decisions should comply with the legal requirement, and the arbitrator himself should at all times comply with the legal requirements. So these are the main duties and liabilities of the arbitrator. Are we good till here? Sumit is asking me, arbitral tribunal shall act on whose direction? Arbitral tribunal does not act on anybody's direction. Arbitral tribunal is like judge. Judge is the person in front of whom both the parties with their lawyers present their dispute to them. There is just the way you see the court proceedings, what happens? Let's say there is a dispute between party A and party B regarding money. So party B was supposed to pay rupees 100 to party A, and it's been a year they did not pay. So what does party A do? Party A goes to the civil court and files a recovery suit, recovery of rupees 100. What he will do, he will make a petition application to the court in which he will mention that I had sold these goods to him. As per the goods, the payment was to be made. The goods were delivered on time. The goods were fit for the purpose. There were no objections raised towards the quality or usage of the good. The goods were well accepted by party B, and thus he is liable to receive the money. Then what will judge say? Judge will serve this copy of this petition that I have given to the judge to the party B. Party B will submit his response, and then he will give evidences. Both the parties and their witnesses will be examined, and then the judge will come down to a conclusion. Either it will say that you need to pay 100 immediately, or it will say you need to pay 100 with interest. So this is how it functions. So there is no concept of any direction or anything here. Is it clear, Sumit? So you need to understand arbitral tribunal is nothing but people, one person or more than one person who are deciding upon a dispute as a judge. So in front of judge, both the parties present their case with their own evidences and set of documents. The judge further will investigate those documents and the case that is brought forward. Party A will make his arguments, party B will make their arguments, and then based on the arguments that is made, the documents that is produced in front of the tribunal draws a conclusion to resolve the disputes and pass the award. Is that clear? Any other question till here? Is this clear, guys? All the topics that we have covered today is clear to everybody. There's no other question that you want to ask. So I think we have only 5-7 minutes left. I will quickly sum up few points. Like I would like to revise section 10 for you. So section 10 provides for the number of arbitrators. So section 10 says that parties are free to determine the number of arbitrators, but the number of arbitrators should not be an even number. But there was case of Loya where the court said that the number of arbitrators could be even as well, but practically you don't get to see the even number of arbitrators. Now, when we talk about appointment of arbitrators, it is either the parties decide on the procedure. If the parties do not decide on the procedure for appointment of the arbitrator, the procedure provided in the Arbitration and Conciliation Act has to be followed. So where the procedure in the Arbitration and Conciliation Act says, where there is one arbitrator, the parties have to mutually appoint an arbitrator. This mutual appointment has to be made within 30 days. And if the parties are unable to make the appointment within 30 days, either of the parties can reach out to the court. Now tell me, in case of domestic arbitration, which court has the jurisdiction to appoint an arbitrator? In case of domestic arbitration, which court has the jurisdiction to appoint an arbitrator? Answers, please. So where the arbitration, please tell me, I'm waiting for your answer. Where the arbitration is the domestic arbitration, it is the High Court which has the jurisdiction. Where the arbitration is the international arbitration, the Supreme Court has the jurisdiction to appoint an arbitrator, correct? Now, the second scenario that has been provided for in section 11 is that where the number of arbitrators are appointed to be 3. So in that case, both the parties are supposed to appoint one arbitrator each, and these 2 arbitrators will jointly appoint a third arbitrator, which is the presiding officer. Now, if both the parties are not able to appoint one arbitrator each within 30 days, then also either party can reach the court. If the 2 arbitrators appointed are unable to decide upon the third arbitrator within 30 days of their appointment, then also either of the parties can reach out to the court for their appointment. Once the court makes an appointment, there is no challenge. But whenever the court is making an appointment of the arbitrator, it takes into the consideration of the expertise or the qualification that was required in the arbitration agreement. Also, it seeks for disclosures. Disclosure in terms of associations, company relationship, biasness, all these disclosures are made. And once the appointment is made, it cannot be challenged. Is that clear? So, this 2 crore funda that I told you, that is specifically for Delhi High Court. Each High Court and lower court have their own defined original and pecuniary jurisdiction. This thing that I mentioned was specifically for Delhi High Court and Delhi District Court, only to give you an example. So the jurisdiction of court is a matter that has been prescribed in the rules of those High Court and the lower courts. But as such, now, when I say High Court, there is High Court of Bombay, there is High Court of Chennai, there is High Court of Delhi, there is a High Court of Rajasthan, there is High Court of Uttarakhand. There are so many High Courts. So in which High Court the matter will go, that is subjective. But when we say jurisdiction as to appointment of arbitrator, you will go to the High Court when it is a domestic arbitration. Where the arbitration is an international arbitration, the appointment of arbitrator will be done by Supreme Court. Which High Court it will be dependent on the jurisdiction of parties. So let's say both the parties of Mumbai, the jurisdiction will be that of High Court of Mumbai, right? So which High Court I am not asking. If the appointment of arbitrator is to be made by court and it is a domestic arbitration, then the appointment will be made by High Court. If the arbitration is an international commercial arbitration, the appointment will be made by Supreme Court. Is this clear? I'm not talking about the jurisdiction on the original side. I'm talking about jurisdiction for appointment of arbitrator. Please remember this thing. Don't get confused with this one, because you will answer the questions incorrectly if you don't get this concept clearly. Is this clear? Pradeep, please be careful on what I am saying. I was talking about jurisdiction of courts for appointment of arbitrator. So for domestic arbitration, the arbitrator is appointed by High Court. For international arbitration, the arbitrator is appointed by Supreme Court. Is this clear? So I was telling you about the disclosures that is made to be court. So disclosure as to biasness, like all kind of relationships that can affect biasness, the previous employments, previous interests in the company, all these kind of disclosures have to be made. So if the disclosure is made by the arbitrator and still he is mutually appointed by the parties, then later on he cannot be challenged on those grounds by the party who have appointed them as arbitrators. So these were the key points that we had discussed. Okay. Any other questions or query on this part that we have completed today? Are we good till here? Okay. So with this, we complete our session for today. We will meet again on 14th of February and finish the remaining portions for Arbitration and Conciliation Act. I hope I was able to address all the queries and questions of the students. If there is anything else or questions that comes to your mind after reading again the study material, please feel free to ask them to me in the next class. Okay, till then, all of you take care, and I would request all of you to quickly revise what we have discussed today so that if there are any concern or questions, you can put up in the next class. Till then, all of you, please take care and stay safe.